They like it when you've got sort of a facing page with all the salient commercial terms of the deal. And then you've got sort of the terms and conditions or the more legalese. So indemnifications and warranties about the product or limiting your warranties, damage caps, liability caps, things like that. If there is a dispute, where are we going to fight it out, right? How's that going to go? Those types of things are there. Those clauses are necessary from a legal perspective, but not something you want to inundate your point of contact as the salesperson, right? Your lawyer can be the best in the world and could be amazing and reputable, like me, but that's not going to help you get a better valuation. That's not going to help you close a deal with a big customer. On the flip side, if you really get someone terrible, it can. And if someone doesn't know what they're doing and the paperwork is all over the place, that could really kill a deal or hurt a deal.
Hello, everyone. It's Alex. I'm back with Ronnie Roy of DME Law. Ronnie is a lawyer who focuses his whole practice on working with startups, and we're really excited to have him. So, Ronnie, do you want to give everybody a little background on you and the firm and your journey?
Sure. My name is Ronnie Roy. I am a corporate attorney. I work with startups and early stage companies. I started practice in 2005, and I was with a large law firm based out of Los Angeles. I was there for 8 years doing general corporate work, a lot of, bigger deals, public companies and such. I left there after 8 years to start my own practice because I wanted to work with earlier stage companies and entrepreneurs. And a couple of years after that, I ended up joining up with some ex-colleagues and we started our boutique firm. There are 6 of us now, and we do work on, exactly that, early stage companies. We work with entrepreneurs, founders, companies that are growing from startup through sale. So we're essentially with them the entire way.
Awesome. Yeah, I know there are probably a lot of stories, some of which you can tell and some of which you might not be able to tell. Yeah. But I'm excited to get into them. Before we get going, one of the things I like the most about catching up with you is your view of the market. And a lot of founders who haven't worked with lawyers a lot don't realize that lawyers know a lot of stuff and they can't necessarily tell you the names involved, but they definitely know what else is going on in the market for companies at your stage and across everything. And so I just love to get kind of your take on where things are in December of 2023.
Yeah, I don't think it's going to be newsflash to founders that financings are down, right? So I think everyone knows that. So I think in my world, a lot of people are having a harder time raising money, and we are seeing that, and we're seeing a little bit more. There are more investor-friendly term sheets that are coming out for companies for financings that are happening, or bridge rounds or follow-on rounds, and that we're seeing terms that we haven't seen in a while. They're coming back, like participating preferred or redemption rights and certain things in term sheets that we wouldn't normally see. And, we can go into more detail, but we're seeing that. And then the other side, maybe a more positive note, we are actually seeing a little bit more work in the M&A space where companies that, are looking for an edge, they can end up combining with another company, merging their companies together. And instead of like an acqui-hire, they're actually working collaboratively and they merge their companies together for, a better offering to the market. So we're seeing a decent amount of that.
So a strategic kind of 50-50 merger in order to, is that mostly cost cutting or just getting, a more compelling story for investors?
A little bit of both, right? There's some redundancies that you can get rid of by combining companies, and but I think there is a lot of the ones that I'm seeing on the strategic side are, well, you do this and we do this, and if we combine them, we kind of have a more wholesome story to tell the market. Paints a little bit more whole of a picture.
Is that like product led, or is that more GTM led? Like, oh, you have this customer base and we can take our product and sell it to that, or is it, our product is incomplete and we're competing with somebody bigger if we combine?
Yeah, I mean, it's funny. I've seen both, a little bit of both, but I think it's I think most of the time it's a little more product based. So even when the GTM is really a part of it, right, it'll be, a combination because someone might have a better way to manufacture the product, right, or better relationships in that regard and things like that. So we have seen that. It's not always just, customer list driven per se, but you do see a decent amount of that going on.
Interesting. And is there anything people should know about like whether that's a good path to think about? Like we'll get into more traditional GTM stuff, but I'm curious, like, is that something you should really think about when you're almost out of money, when you still have a bunch of money in the bank? Like,
yeah, I mean, obviously, if you're running on empty, you're much more vulnerable, and you don't have a lot of, people can smell blood in the water a little bit when things like that happen. So you want to make sure that you start thinking about that, along with your capital raising, you start thinking about that well in advance, right? While you still have some runway, so you can figure out what the right path is. And because, kind of being up against the wall and having to rush into a deal like that doesn't really work, because you really should be targeting someone that you can work with going forward, that the story's right, that the fit is right, personalities mesh, a lot of things like that.
Yeah, I mean, you're working with these people at that point afterwards. And so,
right.
So is there anything that from a legal standpoint or like a founder standpoint, one should be particularly careful of or think about? I mean, and is this maybe related to that? Are you only seeing these with people that have known each other for a while and have been in the same different parts of the same market? Or is it like, oh, I need to go do this, I'm going to run a search for somebody to merge with?
I've actually seen, it's not all, I mean, even if people know each other, they know of each other, they don't necessarily know how the working relationship was. And that, I think, is the key thing that you should look for. I mean, you just mentioned, what should a founder think about? I mean, a lot of times founder or team of founders, they're just used to calling their own shots, right? When you're introducing a whole other team who's used to doing the same exact thing, it's kind of, you got to make sure that you know exactly how that governance is going to work. So in the legal sense, you have to know, how is that decision-making process handled from a legal standpoint? What's the board composition? How are decisions made in this company? Who's acting as the officers? How does that all go, right? And I think that's something that founders don't always consider, because they're thinking market, they're thinking potentials, they're thinking vision and story, but that's a huge part of what you have to do.
Yeah, just a big change in your day-to-day, presumably, as a founder, especially if you don't go on to continue being CEO. When you're talking to a company about that, where's your board? Like, do you go to your board first and say, hey, I'm thinking about doing this? Or do you go put your toe in the water and see, like, is there a viable target or, merger candidate, and then go to your board?
Yeah, I think by and large, it's the latter. At this point, I think you want a little bit more of I think as a founder, if you're going to your board, especially if it's not, a lot of times the board is just a team of founders, but if you're going to a board with external members, you want to make sure that you have your story straight. I mean, you just want to know what's out there, and you want to have an educated view of the market. You want to make sure you're not going with a fully baked deal or something like that, right? You're going just after you've gotten some information, because at the end of the day, you do want to rely on some of your board members to help you. Also, if that's what you're thinking, hey, look, I've identified A, B, and C companies. People might have ins. They might also say, hey, have you considered D, E, and F? Because, if you're telling me this story, it makes a lot of sense. There are other people, other potential partners out there too. So you want to get enough information to have a real vision before you go to your board, but then go to them before, you're not trying to bring them a fully baked deal the first time you talk to them.
So I'm hearing, like, don't go and be like, great, you think it's a good idea. Like, here's the final papers, just sign here and we'll be done, right?
Sign off.
A little bit before. Yeah. Oh, I'm glad you like it. Why don't we just close this right now? That's not a good strategy. Yeah. I mean, your board, I think people have, and everybody I've talked to has said this, they have on the podcast, they have varying degrees of expectations of their board, and they're either expecting way too much or way too little. And I feel like this is one where you will have board members that have good ideas because they probably did look at other companies in the space.
Right. And oftentimes your board members are investors with portfolio companies, right? that kind of, they're somewhat industry focused, so that they have an idea. But really think of the governance. I'm not going to use names, because especially in this case, but I had two clients that were in the media space that came together. And it was one of those grand opening, grand closing deals. They got together. We did a whole deal. 6 months later, they just couldn't work together. We unwound the whole thing. So at the end of the day, you're just spending a bunch of money on legal for nothing.
Oh, and then you just basically extricated them, like combined them, didn't work, and had to undo it. That sounds very expensive.
Yeah, it's a lot of tax considerations and things that are just not fun for anybody. But at the end of the day, that's like one of those things where they just didn't think of the integration plan, beforehand.
Yeah, and so. Well, that's actually kind of before we transition to go to market and the tax stuff that founders can think of, because I think that's when you're structuring any deal, something that's worth thinking about. Curious, going back to the fundraising market, there's one thing that you did mention that I thought was remarkable, which is inside rounds. Because like inside rounds weren't a thing a few years ago. Over the last couple of years, there've been a lot of inside rounds, and almost one of the things I heard was that like if you didn't have a term sheet from your insiders, you weren't going to be able to do an outside round because they wanted it, which is really unusual. I mean, that's never happened before. Is that still a thing? Like, are people still doing inside rounds, or is that kind of dried up, or people already did them who are going to do them?
I think a lot of that is dried up, but no, we're still seeing them. I mean, I'm actually working on one right now. And we just actually had the initial closing, and we're trying to see if the other insiders will participate. But that essentially just happened earlier this month. As a lot of times you're seeing this, and you're actually seeing this across the board. But I've heard a lot of stories from founders and VCs alike that say, "Hey, we're not really looking at new deals right now because we need to have some dry powder for either these inside rounds, bridge rounds, to make sure that our current portfolio companies can get to over this hurdle, right, until the markets open back up." And a lot of people are definitely thinking that way. It kind of correlates. It always correlates. I mean, this is a tangent, but it correlates with the sort of debt returns and that people can get on interest rates and things like that. As those go up, then you see a lot less speculative equity investing out there. But people also want to protect their existing investments, right? And that's a lot of what these inside rounds are about. They're about protecting their existing investments, and it's a signal, right? So if you're talking to an outsider, they're like, "Well, are your insiders participating at least, right? Are they participating?"
Right.
Because
those guys presumably know more.
Yeah, if they don't believe in it, then why should I? Essentially, is the thought process.
Yeah, I mean, it's interesting because a few years ago, even like doing inside rounds was sort of perceived as a really negative signal because you want participation, but you want an outside investor to lead. And, some bylaws actually prevented insiders from participating. And then, things seized up so dramatically a year and a half ago that I felt like the inside round became almost like plan A, where before it was, like your last resort. I mean, maybe because it was your last resort. There was no point in having anything other than a plan Z. Well, so with that, I mean, it's super helpful to understand kind of where things are in the market and give founders some perspective. Because I mean, at the end of the day, for most companies, they're going to have to do a fundraise or a transaction. And so it's helpful to know. But let's go back just to basics. So I'm curious, a lot of people don't realize how much exposure attorneys have to go to market. So can you just share what do you see as an attorney? Like, what are the parts of the go-to-market organization that you interact with? And then I'd like to get into what do you see that is done well? What are the things that are red flags?
Yeah. So it's interesting. I think attorneys do see a lot of it. It just depends on who your attorneys are and what you're going to them for. But and this, we might get into this a little later, but essentially, if you're going to your big national law firm for some of these things, it's not going to make a lot of financial sense to go to them with some of these questions. But someone on my side in the boutique, we see quite a bit of the GTM cycle, right? From sort of the strategy part to engaging outside consultants like yourself, to come in and actually help mold the strategy. So we are involved in those engagements. So we see a lot of that. We see who people are hiring. We're seeing, kind of what's market in terms of bringing someone on to help you with that go-to-market strategy versus, and also not just that, but also what services are they actually providing, right? Because there are people that will come in and maybe provide a little bit of, that will sit with you in strategy meetings. And then there are other people, I know you do this, that will get much more hands-on, will actually handle a lot. You run the gamut. You can handle a lot of the GTM process, not just the strategy, but after that as well. So we see sort of that aspect of it from the planning, but we also see the other side, kind of like the nitty gritty of it. For a product company, their manufacturing deals, their distribution deals, right? And what's happening in the market there. We see a lot of that, even things on the finance side, like factoring and bank lines and things like that we're seeing.
So let's dig in a little bit. I mean, not specific to factoring, but that seems like kind of advanced go-to-market, advanced startup finance. What are the things that you see that give you an indication it's a well-run go-to-market organization?
Right. I mean, first and foremost, it's having a strategy and a mapped out strategy, not just an overall vision, which some people have, or they kind of see the end point of it all, of the final, the final piece of where their go-to-market can take them, or their product can be, but they're not seeing, I think the people that are doing it really well have it mapped out, from step 1, step 2, step 3, step 4, along the process of actually getting their product to market. And this works, this works for actual physical product as well as, I work a lot with mobile gaming companies, with digital media and new media companies and things like that. So it works with both ways, whether you're doing something in an e-commerce setting or traditional, products into retail, or even in the media or gaming space. You have to know what the steps are going to be. And a lot of that also entails knowing the personnel you're going to need, whether they're in-house personnel or people that you can hire and bring in, right? At what steps. And then that's kind of another huge aspect, because I've seen people fail where they just kind of jump the gun a little. They have funding and they hire full-time people that are not going to be fully deployed for a long time, where it really would make a lot more sense to hire someone or to outsource that.
Interesting. I mean, so I think that to me actually is one of my core insights around early stage. You need someone who's junior and generally speaking, relatively junior, very hungry, willing to just roll up their sleeves and do the work. But you also need to write your sales agreements, right? Or you also need to figure out your go-to-market motion. And it's sort of hard to find that in the same person, right? You're hungry, you're young, you just want to close business, get your bonus, you'll go after it. But are you also good at setting up a sales agreement or, running a contract negotiation?
It's interesting because I think that's a good point you're making. It's like the sales skills of actually talking to customers, getting new clients, getting the product, getting people product recognition, things like that, including running socials and all of that, right? I think they can be a different skill sets, particularly for the more junior people. And startups can't necessarily hire, someone who's super experienced that can handle both of those things, at least in-house.
Yeah, I mean, I think one of the things is when they do hire someone in-house who is super senior, they're not hungry and they're not going to go roll up their sleeves and spend, 8 hours in a booth at a conference or walking the floor. Some do, but it's rare, right? I mean, and that's also not what you hire that person for, right? You hire them to set the strategy and manage a team. Yes. And so, figuring out a way to have both, right? Whether that's through outsourced advisory or consulting, to get things set up, and then sort of more junior, hungrier people so they can be fully utilized. So how does that change over time, right? So you start off, as you said, right? You don't want to hire too many people just because you raise money, because you just end up burning through your money and they're not fully utilized, which leads to other problems. But let's say you're, a Series B company or Series C, or you're doing, 10 million in revenue. From your perspective, are the things that people do well the same? Obviously you still need a strategy, but are there other things that change?
Yeah, absolutely. I mean, anecdotally, I'll tell you that things do change, because once you're there, take a SaaS company, for example, right? They'll have their SaaS agreement, and once you start hitting that milestone and you're churning out agreements because you're getting customers sort of faster than you're used to handling, right? And at that point, you actually, so whereas someone could rely on me or an outside person, right? There are a lot of outside sort of contract people that can help you with your SaaS agreements and help negotiate with people. You start having to think of bringing someone in actually in-house to run your chief legal, to actually run this, who's there and dedicated and doing this all the time, right? That like things like that are a key, just one anecdotal example of how you have to start thinking that, okay, now I need someone who does this well in my organization, not just outside of my organization.
Is that a financially, like, what? Tell me more about that decision. Is it financially motivated? Like, oh, my legal bill is X, I would be better off hiring somebody in-house. Is it cultural? Like, I want to sort of manage risk in-house, right? And have this be part of my executive team. Like, how do you think about that?
So I think ultimately it is, it's interesting because the impetus for people to do it is always financial. They're like, oh my God, like, are you looking at this? Like that's what actually leads people. But if you're thinking a little bit more strategically, it's going to be more than just financial, right? It's going to be this idea. Part of it is also, just the cadence of your sales cycle is going to it's going to get smaller and smaller, right? As you get more of a brand, as you get more of a name out there, and you get more salespeople, it's just going to be a much more quick process. And part of it is just to be sure that you're responding to the sales cycle appropriately. Having someone there and dedicated helps your salespeople feel like they're being heard and closing deals because they're working on commissions and they don't want the big holdup to be,
right.
Oh, well, the agreement's in limbo and now the person's losing interest. So that's just helping culturally, right? So that's actually helping your internal culture. But at the end of the day, you want a place where these people are working collaboratively together, right? Instead of like kind of apart. And a lot of times with the hungrier, younger salespeople, they're like, I don't want to talk to the outside attorney. Like this is like, and so either it could lead to mistakes or you get a red line back from a big client and it can either lead to mistakes or just a slowdown in the process. And that just kind of hurts the morale of a lot of your team members if that happens.
Yeah. I mean, let's talk about like the legal part of go-to-market and sales specifically, because the financial one, I'm curious, like, what is that tipping point where you were using outside counsel and you should bring it in-house just on your contracts and your sales stuff?
Yeah, I would say, well, again, it's commensurate with your revenue, right? If you're closing something like 100K in deals for a month, like this is on the smaller side, it's okay for you to spend, to about $5,000 in legal. Like that's the kind of percentage that you're looking for. As you go up, that number is going to go up, but it should never really exceed that percentage. But there's also a critical point. So at some point, you're going to see that, okay, sometimes, we're putting a lot of pressure. They're adding more associates, more people are looking at this, and the legal bills are going up. Even though, and it's going above that sort of percentage threshold, whatever makes sense for your sort of margins on your side, right? Because you've got a budget in place with legal. But so you want to keep an eye on that. But then at some point, even if the percentage is staying in line and your revenues are just going way up, you still have to think about the other side, right? Like the financial burden is still not great enough for you at that point, but you should still think about the sales cycle, the team, the morale, the strat, having that all captured in house and just making sure that things run a little bit more streamlined inside of your organization.
Yeah. I mean, many people don't realize this, especially if they're new to go to market, but like the sales cycle is the most important thing from a new business standpoint in terms of growth. Like the shorter your sales cycle, the faster your growth. There's no stronger lever than closing deals faster. And so you're saying like once the outside counsel becomes a blocker, especially if you have enough deals that they've needed to train more associates to take on the business, and that creates a little bit of friction, even if you're justifying it with what you're spending on outside counsel, it might be time to bring it in for the cultural reasons.
That's right. That's right.
And the high ROI of a faster sales cycle. I like also, just as an aside, the point that as you grow and people become more aware of you, your sales cycle shrinks naturally. A lot of people don't realize that, but like, yeah, if you're a more established brand, people are going to push back on less in your agreement. presumably you've done more to make your agreement palatable to people because you've had more cycles.
Sure.
Let's talk about sales agreements. I mean, what should people think about? Like, what's a good sales agreement, right? I mean, even down to the tactics, like what's on page one, or, and how do you tell if it's not working well?
I think most clients would tend to agree. They like it when you've got sort of a facing page with all the salient commercial terms of the deal. And then you've got sort of the terms and conditions or the more legalese stuff. That is sort of required. Like you need to know that stuff's in there. Indemnifications and warranties about the product, or limiting your warranties, limiting your damage caps, liability caps, things like that. Even if there is a dispute, where are we going to fight it out? Right? How's that going to go? Those types of things are there. Those clauses are necessary from a legal perspective, but not something you want to inundate your point of contact as the salesperson, right? Because that person is not going to be a lawyer either. And then it's going to go to legal. So I think that's one of the things you kind of want to work on as, if you've got a sales agreement and you're working with outside counsel, you want to make sure that it's kind of presented that way so that your point of contact as a salesperson can look at that first page and you can hammer that out, and the rest can go to legal, which should be, those terms won't be interspersed, so that way they'll just focus on the terms that they're thinking about. Obviously, you'll see with a bad agreement, you'll see a lot of red lines, a lot of people just rewriting old clauses because you're just way off market with what you're bringing, what you're asking for, what you're saying. Like, you're not going to get away with saying things like no indemnities, or we're not going to get away with saying things like that. But you want to be but at the same time, you want to make sure that you have the protections in there. You have to protect your IP. You have to, make sure that you're not liable for mountains and mountains of damages should something go wrong. Things like that have to be in there.
Yeah, I mean, there's a lot in there. I mean, I love the idea of like that cover page or order form or whatever you want to call it, but just putting all the business terms in one place. Also, so you don't have to go through to page 15 to figure out like, which just encourages people to look at everything on pages 1 through 14 and find things that they don't like, and tell the lawyers about them, even if they're not a lawyer. And then the other thing in there around the market, I think that, again, back to the thing we started with, right? Lawyers know the market. And so, if you're putting terms in your own form agreements that are not market, and that's not intentional, like there isn't a very good reason for it, you're just making life harder for yourself and extending your sales cycle, because the other lawyers are going to know the market and they're going to push back.
Yeah, that's right.
So I think those are really, really great points. One of the things that I've worked on with some of my clients is getting people to use their paper, and not change it more often. I mean, the best way to do this is a click wrap agreement when it's viable, because there is no way to edit a click wrap agreement generally. But talk about like how do you make an agreement that people will just accept, and how do you manage that as a founder, or as a salesperson, right? That you don't need to send it to your lawyers, and when do you make exceptions?
Right, and so that's a great point. So it's interesting, and I'll go through this a little bit, but essentially, it's very difficult to start there, right? So at least, I mean, I think founders and people in the sales team should understand that it's very difficult to start with a click wrap agreement that's just going to get accepted right away, that you come up with like the perfect thing. Even with experienced attorneys that have done this a lot, it's very difficult to just come up with that right away. So what you're going to do is you're going to have, and especially it's also something that is less likely to happen the younger of a company you are, right? People are just going to be a little bit more mindful and have a little more scrutiny towards your agreement because you're brand new, right? Like that's going to happen. So in the beginning, it's going to be very difficult to do that. So you're going to have this cycle of some red lines back and forth as you hone the agreement to something where you think, okay, we've got it at a place where we're getting a similar comments back from a few different customers, and we can hone our agreement to be what it is. And that's one really way to do it. And it's to know people like you, Alex, like me, that know what market is. That's the other way, right? Just you're going out with market terms, so you're not really pushing the envelope when it comes to things like that. But I do think some of it does have to do with your growth. The bigger you get, the more likely it is that you're going to, people are going to just accept that click wrap agreement. Now, what's going to happen is that what's interesting is people don't realize that you're going to reach a point of inflection. It's just happening with a client of mine who we did the whole back and forth in the beginning. We got our agreement to where it was. They started onboarding customers. Everyone was clicking through. It was great. And then their customers jumped up a tier, right? And the customers became just bigger companies that just kind of have to push back on stuff like that. And that's kind of, and a lot of times, look, like you're not making an exception and you shouldn't. At some point when you've gotten to the point where you're comfortable, this is an agreement that is market and we're accepting it. Don't make an exception for, a smaller client or customer. It just doesn't make any sense. You shouldn't be in that business. You should, but again, there may be an anchor customer or client. There may be someone who's so large or the revenue is disproportionate to everyone else that has asked for something. And there are ways to deal with that. And that's when you use your legal team, inside or outside. And we've done a lot of these sort of side letters or agreements that modify our terms and conditions. And that's what you do as one-offs, not as the norm.
Yeah. So it sounds like, you start with more of a negotiated agreement because you don't know what those agreements need to be. You try and keep it to a minimum. Eventually you have a pretty dialed in agreement that people just click through and buy because you've sanded off the rough edges. I want to get to the negotiating the enterprise agreement subject because I feel like that's something that especially people starting their first company don't recognize that they have leverage on and where the leverage is. So I want to talk about that. But before we get there, are there circumstances with a small customer where you would still negotiate? Like, for example, cities, sometimes cities have specific terms that need to be in agreements. Like, are there certain classes of customer where it's okay to negotiate agreement? Or do you always want to say like, look, you're now an enterprise customer, like there are 2 more zeros on the price tag if you want to do that?
Yeah, I think there are always going to be circumstances. They should be strategic in nature, right? They shouldn't be, this will add, slightly more revenue to us, and so then we should open this up because you're going to start doing that, and it's going to start getting cost ineffective and then really difficult to administer later on as this goes on, right? As you get more and more customers, it's going to be a nightmare. So if there's a real strategic reason, and in your example, you were saying, look, there might be a city in a region that you haven't been able to break into yet, right? And it's a great gateway for you to be able to get into a new geographic location, a new industry, a new whatever, right? Because you know that even though this person's small, it now opens this door for you. That's the reason to do it. So it would be a strategic reason. It wouldn't, because, again, it's hard to say that they're hard and fast rules, but again, if you're thinking strategically and not just saying, oh, well, of course I could just use a little extra revenue, that's going to be short-sighted, in my opinion.
Right. So when you think about an enterprise agreement, where is that line, right? Is it $20,000? Is it $200,000? Like, where typically do you see people be more willing to negotiate?
Again, it's company dependent and just your market dependent. You really want to see it to be like, blank X, your typical, your typical customer or client, right? And I think that number is like fairly large, 5, 10x, 10x type number of your typical customer before you want to open that up, right? So that's kind of the way I think about it. It's not, there are different circumstances based on the kinds of companies people are and the kind of market they're trying to address. But yeah, you want to be fairly close to the vest with that, right? They're called enterprise clients for a reason. I mean, those are really big anchor clients.
Yeah, no, that makes sense. And I think a lot of, especially early on, right, what you're saying is it's okay to negotiate those early agreements when you don't really know what the terms need to be to get people comfortable. But after you've done enough of those, right, now if you're signing another $50K deal, just sign the deal or don't, right? Whereas if you're signing a $500K deal or even a $250K deal and your normal deal size is 50, like that's fine, right? Then maybe be more willing to negotiate. Well, so on the enterprise agreements, what what is typically negotiated? Obviously, commercial terms are important. I don't know if we can cover that if you want, but I'm curious of all the other stuff that's in there, right? Your fine print that's all caps. What are the key? You talked about venue and governing law at the beginning. Like, what are the things that matter that is in general worth paying real attention to?
Yeah, I mean, the keys are going to be really that we get back on are either warranties and indemnities. We get a lot of that back. So a lot of my clients, for example, will say, "Look, we will indemnify you for any sort of claim you might get as a large enterprise client who's using our software that you might get for IP infringement, right? That we did, right? That my client did, but our standard agreement will say something like, for any IP we violate, any U.S. patent or trademark that we violated, right? And larger enterprise clients will say, no, that's got to be a broader brush, right? It can't you're not just limiting what you're standing behind to just violating U.S. patents. If it's any kind of, there's other types of intellectual property in other jurisdictions. We're a global company. We're going to be subject to that sort of thing. So you're going to open that up for us, right? You've limited your liability to 1x, basically what we've paid under this contract, under your typical agreement. We need that to be larger, right? This is a large sum, but we're a bigger company. We want that to be, you could have, or some of them will push back entirely. Like, no, we don't do business with people who have limits on their liability. If you cause us damage, you're standing behind it. And other times you can get.
Sorry, I was wondering, like, is that market? Like, will people say they say that and it's a negotiating point, or they say
it's a
that
negotiating
it's real?
Yeah, so you end up with some multiple of the payments made. Our typical agreements will often limit it to the payments made in the prior 12 months or the prior whatever, and some of them will push back on that time limitation. They'll say, no, let's make it about payments made through the entirety of our relationship, or let's make it for blank X the payments made for 12 months, for the last 12 months. And
how much of this is like a deal breaker? Like, how often does an enterprise agreement go to counsel and actually not happen because of
the only times I've seen it, and I'll say from my perspective as company counsel for my, the provider here for the company going out there, not the customer counsel, but for company counsel, I'd say the biggest deal breaker for us is if people are really pushing hard on the IP protection sections, right? Like where we're saying, no, this is our technology, especially like if you think of like a SaaS offering or something. I have a lot of clients who do like integrated software where they'll come in and they'll put it onto your platform or whatever. But that's our technology. If we're starting to hear pushback about that and how you want to try to take away those clauses around our background technology and ownership and ability to create derivative works or competitive works, that's going to be a big problem for us, right? And similarly, I think if you're taking hardline indemnities if you're taking hardline positions as a company, if I was like on the other side as client, as customer counsel, and someone was saying, we're giving, you have to take the product as is and we're not standing behind it at all, or something like that, that would be
right.
That would be a big red flag to me.
I mean, that actually gets to another perspective, which is like, at what point is it enough money to care, right? Like if your license is $5 million a year and you're limited to 10x, your damages aren't limited until you have 10x damages. That's getting to a bet the company kind of amount of money, and people are going to lawyer up if things go sideways. But if it's $100 a month or $1,000 a month SaaS product, even with a pretty big, multiple on the limit, like it's not, people aren't going to call their lawyers to get $12,000 out of you.
No, that's true.
Or
right.
are they?
No, they're probably not. Right. They're probably not. So you're right. It is an order of magnitude, and it's a matter of how much you care. But it's interesting because there are really big enterprise clients out there that will try to get an MFN type of thing that will say, well, whatever term you've offered someone else, we want as favorable of a term. So you still have to be careful about those kinds of what when a multiple or multiple liability cap that you're going to put in. It's not that often that happens, but you want to be careful.
Yeah. So the MFNs, I mean, that's a fun one to talk about, right? You're an early stage company. You've got this sort of whale on the hook, right? And they say, great, well, we want this MFN clause or we want exclusivity, right? Is that, I mean, I realize these are more business terms, but what's your advice to clients that come to you with, hey, I've got Verizon or I've got Delta Airlines or something, but they want this. I made those two up, by the way.
MFN could be, that's something that we can talk about, but exclusivity I always warn about, right? Like, if you're thinking about it, and a lot of my clients are growing, right? And we know that we're heading into the next round of financing, for example, right? And all of a sudden you're going into that and there's a story you're telling with numbers, and which include market size. Now you've cut off a portion of the market by giving an exclusivity. Right, MFN is not as big of a deal. It can be in terms of pricing potentially as it hits your bottom line, but actually those exclusivity clauses, I feel like you really should either try to make them really narrow, limited in scope, or limited in duration, right? To be able to get the big guy on the hook. Maybe yes, okay, for the next 6 months, the next 12 months, we are not going to go after anyone, so you'll be the first one with our product and have a runway with it. And then we're free to do what we want, because if you're cutting off whole portions of the market, you're really running into issues down the road.
Yeah, there's a point in here around like, how do these agreements and your go-to-market affect your fundraising and what comes up in diligence? I want to get to that in a second. Something else that kind of triggered was how do you handle your corporate venture arm, right? Oh, we want to do this commercial deal, but we also want to invest. And along with that, we want this exclusivity agreement or this MFN or this ROFR or something. Like, have you seen, I feel like I've seen, so I'm curious, have you seen an uptick in corporate VC transactions and what's market, like, how do you handle that? What's a good way to think about it?
We always do see that. And then like that's always interesting to me, because we see it in a couple of ways, right? I see it on just someone in the same space as you. Like, so this is not necessarily what you're talking about, where you're, in your GTM phase and one of your clients is trying to use their corporate venture arm to gain some sort of advantage over their competitors, like an exclusivity. I see that, but then there's the other side of it, which we don't have to get into as much, but you see a lot of it with these strategic people in your own industry that are like, oh, you're an up and comer in my industry. I want to invest in you, right? And I want to see what you're doing. You're an independent company. It's cool. This is never going to fly at my big media conglomerate. I want to invest in you. And so you see that a lot. And you just have to be super careful on that side, on the strategy side because a lot of times people will just put in these terms, and if you give them the same terms as you would give like a VC firm, the VC firm, you can always just count on acting sort of economically rationally. There are things where if you give certain blocking rights or some things like that to a strategic investor, they can really hurt the future growth of your company, sort of selfishly, because they want to make sure they're holding it. Their play is trying to get a hold of your IP or making sure it just stays kind of in a controlled environment for them. And so that's that side of it. On your side, it's interesting. You often see this happening where people are promising both. But what I'll say to most people in that sense is, look, again, think bigger picture. Like if it's someone who's participating in a round, if you have a round open and you've got a customer who's willing to participate through their corporate VC, then they should just adhere to the term. They should fall in line, essentially, because they're just
right.
You want to try to do that as much as possible, right? Just get them in on the same terms as your other investors, right? And that's kind of one of the things I say. And then again, think a little bigger picture. So again, it might be a really good customer to have, and it might be enticing to have some extra capital, some dry powder for you. But see if you could limit their asks to something that's not going to impede you indefinitely, that you can do something where you can bring their asks down. And you are seeing an uptick in that because there are some of these companies that have some cash on hand and they're able to actually do this. Whereas, like we were talking about before, you're seeing less, sort of VC-led deals out there. So it can be enticing. You just have to have an eye towards the future.
Yeah, I mean, there's a lot in clean tech. Just, I don't know why that happened, but there's a lot more CVC activity, corporate VC activity early on, much earlier than even at the seed stage. I mean, and you kind of see it with like Rivian and Amazon, where, right, Amazon got a huge chunk of Rivian, also did this company making van deal with them, right? So you can see why, from a bunch of reasons, Rivian would want to do that. But like, they're kind of, it's very hard for them to go sell to the post office or somebody else, given that Amazon, maybe the post office is a poor example, but UPS or somebody who doesn't get along well with Amazon has a bunch of rights. And so it can, even if there isn't an explicit exclusivity, there can be a de facto exclusivity because people just don't like.
Well, they've associated, even if they're, exactly. So they've associated those two groups together, and now they know that, sort of every dollar that Rivian makes, Amazon gets a benefit from.
Right. And they might get information rights too, right? I mean, sometimes you can limit it, but if it's a direct competitor, but if Amazon's getting information rights and UPS is ordering trucks, like, they get to know how, on some level, they might get an idea of how much business you're doing with them, which might not benefit them. But so, I mean, to me, the corporate VC, a lot of founders end up in these complicated deals where they're negotiating a commercial deal. They're trying to close around. The corporate VCs are very eager. They want a piece of the upside. It's happened to one of my clients recently. It got this sort of really big, deal on the line, and somebody in finance was like, "Hey, we want to invest too," and it's like, "Oh, we don't need your money. We don't want your money. Like, it's just a commercial deal." I mean, what I've always said, I'm curious what your take on this is the commercial deal should stand on its own. You should be able to do the commercial deal,
and that's kind of
without an investment.
Yeah. That's kind of what I was talking about before. Like, let's say you have a round open. That's great. So, like, let's do a commercial deal, and then we can talk. I can send you the term sheet that our lead investor sent for the round, and you can participate if you want, right? Like, throw in 50K or 100K, whatever it is. Like, you can participate in that if you want. But it's not, but that you are really by. I was saying that, I think we're saying the same thing. It's so much better if you can do that. It's just that that a lot of times these corporates are using they're using the leverage, right, that they have to try to
and they want, and they might want to be taking you off the board, which has happened. I mean, a friend of mine's company, Harley Davidson, invested, and when they needed to raise more money, they made it very, very hard for them to raise more money, and they ended up having to shut down.
That's what I always tell my clients is, like, if you're getting strategic money, right, from a company that's out there, you just have to be so careful. You can't just give them the suite of rights that you'd give a VC firm. Right. Again, they have different motivations.
Right. I think that's so important. Well, so that gets maybe our one of the last couple of questions I have for you, which is what are the mistakes? Like, where does this GTM and, CVC, all this stuff we talked about, like, what are the landmines that you could step on and maybe not know it until you're doing a transaction? Right? What are the things that you have to bear in mind when you go into either a fundraise or a sale that can hurt you as a founder, maybe tax structure, or you as a company, or getting that sale done?
Yeah, so I think we talked about this earlier. We've touched on this for sure, but granting people rights that impede your future growth, in whatever capacity that might be. Right. And you touched on it, could be giving someone information rights, too much information or something like that about your operations. It could be granting someone exclusivity. It could be whatever it might be that will hit your market. Will just, that's something that's just anything like that just reduces your total addressable market. And anything that's reducing your total addressable market or it has the potential to reduce your total addressable market, you have to really be mindful of that.
Is that because it reduces your purchase price, or does it kill the deal entirely? Somebody gets into diligence and says, oh, whoa, like you can't go after Europe because you gave that away, or you can't go after so-and-so. And so they're like, we're out. Or they're like, oh, great, we're going to haircut what we offered you.
So it depends on what you've given away, all right, or how much you've reduced it. I mean, sometimes it's so fundamental that you've kind of said one thing in terms of addressable market, and it's so vastly different that people will pull out. But by and large, you'll see what you were talking about. It's like, oh, no, the valuations that we were talking about were for something else. Now we're just going to haircut it, or things like that which ends up leading to more dilution and problems for the founders on that front. And so that's one that. So I think it's usually more the latter, unless people are reckless and are not at least time binding those exclusivity rights or things like that are so that they might fall off after a certain amount of time.
Then you get like, oh, in 2 years we can go after Europe. So fine, we can still count it as part of the
exactly. But and things that are sort of more on the deal breaker side is, a lot of times we see they have to do so much capital raising because they've had so many starts and stops or pivots and this and that their cap table is completely upside down, and their investors own way too much of the company, vis-a-vis management and founders. And at that point, that there's not much you can do, right? As someone coming in, aside from a total recap, and those transactions are very complicated and tough to get through. Your standard financier, your standard VC fund is going to look at that and say, I don't even want to touch this, right? This is,
and so they'll just pass because it's like the founders don't have enough, right?
Yeah.
Oh wow. Even if you're, I mean, I've seen this, so I believe you, but it's kind of shocking probably for some people that it's just the team and the founders. There's no amount of options pool you can do to get them back to a meaningful level.
I think there is a little bit of that going on, but at some point, if you're so upside down, it kind of, because any new options pool kind of dilutes the existence. So you're talking about kind of a crazy number, and so sometimes it's hard to recoup from. It's also like. Yeah, it just also depends on the stage of your company. If there's enough upside to be had from the point of a new financing to the exit, then the options pool is really helpful as a motivating factor. But I think similarly in the GTM side, if you really gave away the farm, you'd be in a lot of trouble. GTM side.
Yeah, I think it creeps up on you, especially in a market like this when terms are just worse than they have been.
Yeah.
So last couple of questions, or like they're wrap-up questions, but before we get that last question, tell me more about the decision to use a boutique firm like yours, and you mentioned there are others out there, versus white shoe firm like where you used to work, like a Fenwick or a Wilson or O'Melveny, somebody that everybody's heard of.
Right. So I think it's interesting. I think the decisions are few. You have to be cost conscious because you're talking about an order of magnitude of cost difference, right? And you have to think about what it is that you need from your law firm. There is certainly a time in someone's life cycle when they're very large and they're thinking of they're close to IPO, or they're going to do some cross-border, they're doing some cross-border, like where's the Singapore-led VC that's going to be leading the, things like that are clearly you've got to go to someone with that kind of global touch, or the larger touch. And because there is something to be said on both sides. Like, okay, you need someone with a presence in Singapore if you're going to have this Singapore-led VC. You need, if you're going IPO, you kind of might have want someone like Wilson or O'Melveny's name on your SEC paperwork so that the SEC is like, this is probably pretty legit when they look at it, when they look at your S1. So they're obvious answers, right? And on the other side, I would just say, look, I don't know what the exact line of demarcation is at all, but I'll say this. What you want to do when you're choosing your lawyer is find someone where you understand the cost structure, you understand what it entails, how it's going to fit within your budget, and then I think most importantly, talk to them, see who's going to work with you Like, who's going to be on your team? Who can you reach realistically?
Yeah.
Who are you going to talk to? Who's going to help you with the strategy? So I think a lot of times people choose law firms for the wrong reasons. They think that there's a name brand or a cachet. And I got to be honest with you guys, like your lawyer can be the best in the world and could be amazing and reputable, like me, but that's not going to help you get a better valuation. That's not going to help you close a deal with a big customer. On the flip side, if you really get someone terrible, it can. And if someone doesn't know what they're doing and the paperwork is all over the place, that could really kill a deal or hurt a deal. But, once you reach a level of competence, that's not the reason to choose your lawyer, right? Like that you think is bringing you some cachet or it's bringing your company some cachet. The reason would be, okay, this person I get along with. I think in the early stages, especially important because, who am I going to be able to talk to? I've got a lot of strategic decisions to make, a lot of things I need to understand about the market. And trust me, there are people at those firms that really know that stuff. But are you going to be able to talk to them about it? Are you going to actually get a
right? That's a great point. Like, who are you? Are you talking to a first year associate who is busting out their legal textbook to figure out your agreements? Or are you talking to somebody who's really experienced? I think, can you give people a sense of the order of magnitude business, like for a Series A difference? I'm sorry, between a boutique firm and a white shoe firm for like a Series A financing.
Yeah, so for the Series A's, and it just depends on how much cleanup is necessary, because a lot of people don't go to lawyers until they're Series A, and then like their corporate books are kind of a mess and need to be cleaned up because there's going to be a heavy amount of diligence. But I would say that you're probably talking about 3x in cost difference, and it's interesting because there's a lot of things to be gained by having an experienced attorney in your Series A, because there are terms in there in the term sheet and everything. But at the end of the day, everyone works off the same docs. Like the templates are the same for everybody, right? So nobody's reinventing the wheel. So for there to be that big of a cost difference, you have to really be cognizant of that, because again, so I think that where you really need someone with the experience and know that you have their ear is when you're negotiating your term sheet, because that's where the salient terms are going to be for Series A. But you are going to you're talking about a 3x difference at least, right? Like, we're doing those at seed rounds and Series A. It's still in the 10, 15, 20 range, and that's going way higher in the bigger firms.
I've done some with the bigger firms, and it was definitely 3x or more.
Yeah.
No, this has been great. So I really appreciate your time. I have a couple of questions I ask everybody at the end, just to get a bunch of different perspectives on similar stuff that is always really interesting to founders. The first one is, just in case we missed anything, is there anything that you wanted to cover that we didn't?
I guess maybe I just want to make sure people understand that I think it's helpful in your sales cycle if you find someone who knows your industry, has worked in it before, and who knows how to kind of do those agreements. If you're working with an outside counsel or a person like yourself, Alex, like I know you've worked a ton with clean tech and kind of electric cars and places, things like that. So it's really helpful if you get someone like that, because they know the market so well. So when you're crafting your agreements, when you're crafting your strategy, it's at any stage of that, I think that's huge. And there are resources out there, right? There are specialty boutiques, and you find there are people like that can do that. They might not be able to help you with your Series A per se, but they will be able to help you with your go-to-market agreements and things like that. So I think it's worth looking for that. It's not, your lawyer doesn't have to be your one-stop shop for every single thing that you do.
Yeah, no, that's great advice. Well, so the couple of questions I asked everybody: three best practices that you wish every founder would do on any subject, not just go to market.
Okay. Yeah, please, you have to issue equity properly to your team. So many people come to me, as they're getting interest from outside investors, and they say, okay, great, I have this company. And I was like, oh, perfect. Send me the documents. What do you have? What you've done so far? And they send me a very bare bones things that maybe shows only one equity issuance to the founder themselves. But they're telling me about all these team members and they've given me a cap table. And they're like, oh, well, I told this guy 4%. I told this guy 2%. No vesting terms, no paperwork, no nothing, but just kind of like maybe offer letters. Even that isn't enough, right? If you're not issuing equity properly, you're really hurting yourself and you're hurting the recipients too, because ultimately when you get around to actually issuing them equity, you might have grown and you can no longer give them a tax efficient way of acquiring that equity. You now have to grant options with a higher exercise price or what have you. And that gets really problematic. So that's like first and foremost. And I'd say the second thing, because these are things that come up in diligence. It's like the main two things that I always see people worried about in the diligence standpoint is your cap table, do they tick and tie to documents that we can find in a data room? Second, is your IP secure, right? That's the other main thing that I would say is best practice. Make sure everyone signs like a CIIA, like confidential information and inventions assignment agreement that works for you. That's like your work for hire and your NDA all rolled into one. You want to make sure everyone's doing that. You want to make sure you've actually went and filed or secured important IP to yourself, whether they're patents or your trade name, your trademark, your logo, what have you. Make sure that stuff is secure, because that's the other thing. That's and if you're doing something like a software related thing, you have to be very precise into how that software is built, how much open source you're using, what are you doing, and then to the extent that you have built something proprietary, what steps have you taken to keep it in-house only, and make sure that it's a true trade secret or it's your own proprietary information. I think that stuff is pretty important, because ultimately that's your ultimate value.
Awesome. Those are phenomenal. And yes, I've seen both of them not done right and cost literally tens of thousands of dollars to clean up. So, and hold up transactions, which is never something you want to see. So those are great. The best advice you ever got?
Oh, that's a good one.
You don't have to have taken it, by the way. It could be the best advice you didn't take too.
Yeah, I'd say, I mean, obviously, I think the best advice I've ever gotten, because like I'm a founder myself. Like I started this boutique practice and I'm kind of setting it up. It is really to have steps beyond your vision. Like you could have a vision to say, I want to be the preeminent boutique law firm on the West Coast, right? Well, how are you going to get there, right? And unfortunately, some people say, well, I'll just build the best product. I'll give the best legal advice. That's not enough, right? You have to know, like what are the steps from your end goal, from where you are now to your end goal? Can you map it out with some sort of precision? Can you work towards meeting each one of those as you go along?
That's awesome advice. Well, so I really appreciate you coming. Where can people find you? What should they know about DME law and how can they get in touch if they want to?
Yeah, that's great. Thanks. You can always reach out to me via email. It's Ronnie at DME law, right? That's really easy. You can always do that. On all the socials like LinkedIn and things like that. So I'm there as well. What about us in general? Like I said, we're a boutique practice. We have a side of the house that works with early stage companies on the corporate side, whether that's like I said, there's finance. We do a lot of Series Seed A, B rounds. We do a lot of corporate structuring, and we do a lot of M&A work on the corporate side, as well as these sort of outside general counsel, helping people with their SaaS agreements or their manufacturing agreement or distribution agreement, things like that. And then we have another side of the business that really does a lot of digital media content work. So, that's something people can be interested in. If you are, then there's no one better than our guys that do that.
Great. Thank you. I can't emphasize enough the importance of that first piece of advice of just getting things straightened out the first time, of issuing your equity cleanly, and working with Ronnie and firms like his is a great way to do that. What is it? A pinch of prevention is worth a pound of cure. Like that's, I've seen what it looks like, and it's not pretty when you have to clean that up.